Welcome once again to Lehto's Law. Here's Steve Lehto.
Zachary sent me a story, thank you very much. And this is from the ABA Journal, the American Bar Association Journal. Suspension imposed after appeals judge is accused of making himself a beneficiary of his ex-client's will. And this is an example of one where I don't really explain to you what's wrong there, do I? Before being a judge, apparently, he was an attorney, and he's still an attorney, obviously, as a judge. But practicing as an attorney, created a will for somebody, and he wrote himself into the will. And we'll talk about some other aspects of that, but Deborah Kassens-Weiss wrote it for the ABA Journal. The Georgia Supreme Court has suspended a state appeals judge with pay during an ethics investigation. Now, the suspension has been made good, so I'm not sure if he's still getting pay or not, but the court suspended the judge recently. He's accused of making himself a beneficiary and his wife the executor when drafting wills for then-clients, according to various sources. He's also accused of drafting an irrevocable living trust for the client that designated himself as the trustee and beneficiary with the power to transfer funds to himself while the client was alive, according to the Judicial Qualifications Commission of Georgia. A company owned by the same attorney is also accused of borrowing over $300,000 in a series of 3 loans from the client, the first of which was paid off on the day the second loan took effect. 2 of the loans listed the client's home as collateral, which the attorney later attributed to a scrivener's error. Little typo. The third loan was unsecured, and he has since repaid all the loans, but this is all still very, very bad. The former client is now 79 years old, and the commission said that in December, he was complaining about all these things, understandably. The attorney began representing him when the client sought guardianship of his girlfriend in a nursing home. The attorney charged $80,000 for the representation, but did not provide itemized billing records when the client asked for them, which in most states, you are required to provide itemized billing statements when they're requested by the client. You can't just tell the client, I charged you 50 grand, or I charged you 80 grand. For what? I don't have to tell you that. Can you imagine? The commission also alleged that the attorney transferred funds from his campaign account to his law firm account to cover minimal or overdrawn balances. The charges also alleged that he declared a $50,000 loan to his campaign that was fictitious, according to previous coverage by the Atlanta Journal-Constitution. So he had other problems besides the self-dealing with the one client. His attorney, yes, the attorney's got attorneys, issued a statement that strongly denied the allegations after ethics charges were filed. The allegations misstate the facts and the law and significantly overstep the jurisdiction of the commission that was looking into this, according to the statement from his attorney. The statement said the Government Transparency and Campaign Finance Commission had not found any campaign finance violations by the attorney, and it's inappropriate to base judicial ethics charges on violations that fall within the jurisdiction of a different agency, and of course, that's not the case. Attorneys have very, very high standards of ethics that they're held to, and it doesn't say, oh, we'll only hold you to these things, but not these things but not these things, or not these as long as they're covered. No, they just go, you do this stuff, or don't do this stuff, whatever it may be, and it doesn't matter if someone else has the jurisdiction to cover it. Otherwise, a police officer could arrest an attorney for something good, and they'd be charged with a crime, but you couldn't go after their license because they're being charged in another court. Another agency's taking care of that. No. These things overlap. So the attorney at issue here had agreed to an interim suspension while denying any wrongdoing. At first, the Georgia Supreme Court had refused to suspend the man because the Judicial Qualifications Commission did not provide an affidavit or other verification by someone with personal knowledge of the facts supporting the allegations of ethics violations. On Wednesday, the court said the commission had since provided it, and there you go. So the man's a former Georgia state representative. He was appointed to the Court of Appeals in 2018 and then elected last year. A retired judge was appointed to fill in for him now. The ethics investigation began after a lawsuit alleged the attorney had committed malpractice, fraud, and breach of fiduciary duty in his representation of the client we talked about earlier. That suit has since been settled. So a couple things come up here, one of which is someone's going to think of this. You already have. What if I was really good friends with an attorney, And I went to him and said, I want you to prepare my will for me. Okay, I can do that for you. And I want to put you in the will. I like you. I can give my money to anybody, right? I want to put you in the will. As an attorney, you have to tell that person, if you really want to put me in the will, you have to understand that if I draft your will, it won't look right. I have to suggest to you that you get someone else to do the will for you. That way, when I pop up in the will, no one's going to say, oh, he wrote himself into that will. It looks bad. And you could put anything in that will you want. You could have it say things like, I understand this looks bad, but I wanted to do this to save money. And one of your relatives who would collect otherwise, that you may have left out on purpose, is going to come into court and say, that bad attorney influenced my dear double secret cousin, uncle, nephew, because we're related like this on a family tree that goes sideways instead of vertically. And I think that he used undue influence to get him to sign that. And a court will look at that and they're going to have to go, gee, that's kind of strange. And this is, I've used the term before, it's a trap for the stupid. It is a trap for the stupid. If someone came to an attorney and said, go ahead, write yourself into the will. I can't. I can't for obvious reasons. So the fact that he wrote himself into a will, and that he also did the stuff with the irrevocable living trust that designated himself as a trustee and a beneficiary. The way those work is there's a trustee who oversees the trust and how it dispenses things, and then the beneficiaries are the people who get the stuff out of the trust. So by being both the beneficiary and the trustee, you immediately spot you have a conflicting interest there, right? You can hand yourself money. I'm the trustee. I think I should give myself some money as a beneficiary. Thank you very much. You're welcome. Again, that's not even a trap for the stupid. That's beyond a trap for the stupid. That's the kind of thing where any court is going to look at that and go, boom, problem. That's a problem. You cannot discharge both of those duties at the same time. Pick one. Okay? But you can't. And so if you wrote yourself in as a beneficiary of the trust, people are going to go, wait. You drafted the trust. You made yourself the trustee. You made yourself the beneficiary. That's a whole boatload of ethical problems right there. And so this is the kind of stuff where once in a while somebody will get caught. And they'll do the investigation is ongoing. We're going to get to the truth. We're going to fight this to the bitter end. All will be revealed one day. We've heard of these things, right? All you have to do is walk that trust, which would be a document, and put it on the desk of the commission that oversees these things and go, just read it. Did you notice who drafted it? Did you notice who the beneficiary is? Did you notice who the trustee is? Okay, done. I mean, there's no need to go beyond that. That's crazy. So the guy appears to have been taking advantage of a client, and it's malpractice, at least, and it's potentially a lot more. And I know people like to crack jokes and make fun of attorneys when we talk about ethics, and it's unfortunate because a lot of professions out there don't actually have ethical considerations the way attorneys do. And so attorneys who act unethically can lose their license to practice law. I'm not sure, for instance, if airline pilots, the FAA, can lose their license if they're unethical. I'm not talking about breaking rules of the FAA. I'm talking about just in their everyday life. Okay? An attorney who does something unethical anywhere in his life runs a risk of having a problem with his law license. And so we're actually held to a very high standard. And again, I know people aren't going to believe that, but I'm just going to let you know one little fun fact. I went to law school. I wore the t-shirt a video ago. I went to law school at a place called Southwestern University School of Law in Los Angeles. And I was in a program called the SCALE program, which is a 2-year law program. So you're in and out under 23 months. Very, very high washout rate, but the people who graduate tend to do well. And I can tell you that on day one, hour one, the first class that I had in law school, literally, I showed up. I'm a bright, shiny law student on day one. I show up and I walk into the first classroom the first day, and I sit down in the back row, far right-hand corner from my perspective, far left-hand corner from the professor's perspective, sitting next to my good friend Dave Reinard, who's an attorney in California right now. Next to him was Mike Kowalski. Next to him was Steve Carroll. I know this stuff. Day one, class one, ethics. The first class I took, first class these guys took, first class all of us took. And that class continued for the semester. And we took other classes. And every law student out there, right now, some of you are going, well, I took ethics too. Of course you did. Every law student took a class in ethics. So every lawyer who went to law school took a class in ethics. And I'm simply pointing out the irony of it, that it was the first class that I took. Day one, first class. 8 o'clock in the morning, walk in, broke open the ethics book. So remember, brown cover, gold lettering on the cover. So ethics is very, very important to lawyers. And it's actually one of the things that you look for in an attorney. You go to hire an attorney, you want an attorney who knows the law, knows the court system, and can communicate with you and will be ethical. And those are not in order. Those are all equally important things. You don't want an attorney who doesn't know the law, doesn't know the court system, can't communicate with you, or doesn't have any ethics, okay? You want all of those things. You want all of those things. And obviously you want a good result, but you want a good result with those things. So the suspension has been imposed after the appeals judge is accused of making himself a beneficiary of his ex-client's will, as well as the beneficiary and the trustee of a living trust that he drafted himself. So there you go. It's a problem. Zachary, thanks for sending it from the ABA Journal. Deborah Kassens-Weiss, and it's a great story. Questions, comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. With every mistake, we must surely be learning.